Hey guys, Kate Bihm here, family lawyer in Montgomery County, Texas. Remember, I am a lawyer, not your lawyer. This is just for public information purposes. And to the extent that this is different than what your lawyer is telling you, you should trust their advice. You're paying them. Today, I want to talk to you a little bit about mediation. Mediation is commonplace in family law cases. I often have people come to my office on their first consultation, and one of the first things out of their mouth is to say, I don't want to go to trial, I want to go to mediation, we expect the case to settle. And that's great. And I love to tell them, we're going to go to mediation because in our local courts, it's court ordered every time. So, how do you adequately prepare for mediation and what you can expect? So when I talk about mediation, I'm talking about the mediations that we have here locally and that I usually participate in with my clients. If you are in another state or another jurisdiction, it might look different for you, and you need to be mindful of that. So mediation is a process where the parties agree typically, or sometimes the court can order, that a specific mediator will assist the parties in resolving their dispute. We have two different types of mediation that we typically go to. We will go to mediation for temporary orders relatively early on in the case, or we'll go to mediation prior to final trial. At mediation for temporary orders, we're talking about who gets to hold what while the case is pending, not keep what when the case is final, and what is going to be the temporary arrangement for custody of your children while the case is pending. At final mediation, we are talking about a long-term child custody agreement, long-term child support, and the division of property right down to who gets the love seat versus the sofa. One of the best things that you can do to prepare for final mediation when it comes to the division of your property is, before you move out of the marital residence, go room by room and take pictures of everything. Take pictures of what's on the walls, open up each closet door, take pictures of what's in the closets, take pictures of what is in each drawer and each cabinet in your kitchen. That way you can remember what it is that you have that needs to be divided. You're also going to want to prepare to divide big major assets like your house or the retirement accounts. And in order to do those things, you're going to need to have some value associated with them. Now, if you're thinking that you want to buy your spouse out of their share of the equity in the house, before you go to mediation, you need to make sure that you qualify for the loan that it would take for you to do that, or that you have sufficient cash reserves or retirement in order to buy them out of their fair share of the equity. Now, there's going to be another long-form video that you'll be able to see, which has a more thorough discussion about how property gets divided in a divorce. Today, I'm really just focused on talking about mediation, all right, and what you can expect. Mediation is a high-pressure environment. It can be very emotionally difficult. It's commonplace for the final mediation to be the first time that a lot of my clients are really taking in and processing the fact that their marriage is about to be over. So one of the best things that you can do is emotionally prepare for that idea and get ready for you to learn some things about your spouse's expectations or your co-parent's expectations that are disappointing to you or hurtful to you. All right? You need to get ready for that, because what you don't want to do is you don't want for your time with the mediator and your time with your lawyer to be derailed by a long period of time emotionally processing what is happening. I can remember one mediation that we had where my client sobbed for 4 hours straight. It was crushing. It was so sad to see. But she was so emotionally upset about what was happening that we didn't get anywhere with the mediation. And it was a total waste of money for my client. And that was very disappointing. So you really have to prepare and think about what it is that you are hoping for your outcome to be and what would be something that might be a reasonable resolution that might necessarily meet your expectations. A lot of lawyers and judges would say that if everybody leaves mediation thinking that they gave too much, it's probably a pretty good result. Okay? And so what you have to be willing to do is to go in with an open mind and understand that going to trial is often significantly more expensive than settling. So you really need to rely upon your attorney's advice as far as what's reasonable versus what's not a reasonable negotiation, and be willing to consider all of the different ways that your case might be settled, whether it's mediation for temporary orders or mediation for final trial. Where I live and practice, mediations typically take place something like this. I'm in one room with my client, and opposing party and opposing counsel are in another room. And then the mediator goes back and forth between the two rooms trying to negotiate some sort of compromise. In my experience in family law cases, you are very rarely expected to sit across from your spouse or co-parent at a table and hash things out. Because let's face it, if you could do that, you probably wouldn't be splitting up, right? That's why there are irreconcilable differences. You really have to trust the judgment of the mediator to know how to best position various offers or issues in such a way that they'll be effective. That's one of the reasons why it's a good idea for the attorneys to agree on who the mediator is going to be, because I will really seek out a mediator that I think is going to be a good fit for my client and a good fit for the case, and often a good fit for opposing party and opposing counsel. We want a collection of personalities to come together to come out with one result that everyone can live with. The mediator is not the judge. Mediation in Texas is confidential. That means the mediator can't be called as a witness to come into court and testify about who should win, what the facts are, what gets said in mediation, and what the different offers are. Under the Texas rules of evidence, most settlement negotiations are inadmissible. So you might make an offer in mediation that you are strongly considering it, but you don't even want to say that you might accept it because you're worried that if the judge found out, you wouldn't get X, Y, or Z later in trial. But that's not the way that it works. When I'm the mediator, I always want the people that I'm mediating for to feel comfortable being candid and telling me their real thoughts about how things might work. Because by understanding their thoughts, and then when I understand the thoughts of the people in the other room, that helps me to broker some sort of compromise. Mediation can be a fantastic thing because often the mediator may have some creative ideas that the other two lawyers either haven't thought of yet or have not thought that the parties would be willing to agree to. I've had multiple cases where I'm actually really surprised when we walk into mediation because the mediator says for the first time in the case, hey, I think they'd be willing to do this, or would you ever be willing to do that? Because I think that is what they're hoping for. And my client looks at me and I look at my client and we're like, are you kidding? Did they really say that? Yeah, we'd love to do that. And then suddenly the tension goes out of the room and we're really getting somewhere. So just be mindful when you go into mediation that an open mind is one of the most important things you can do to prepare. Also, when you go to mediation, you've got to be ready to make decisions, often very quickly. One of the most important things that I tell my clients before we go to mediation is, I'm going to need you to be ready to pivot. A lot of times going into mediation, we don't know what the expectations and the desires of the other party is. And so if we really, really want one thing, but we don't think the court is reasonably likely to order it, and then the other side says, I'm never going to agree to that one thing, We need to be able to move on really quickly in order to use our time effectively. So you've got to be nimble, ready to pivot, and ready to move forward to make decisions. And sometimes it can be really crippling. I've definitely had cases in the past where when it comes down to it, my client has not adequately prepared for living independently. And so mediation is the first time that they start thinking about what their bills are going to be, how much rent is going to cost, what health insurance is going to cost for them once they're no longer carried by their spouse. Those types of things, you need to know the answers to those questions before mediation because they're an important part of the negotiation. I can't tell you how many times I've been on the phone with the health insurance agent in a mediation trying to figure out how much health insurance is going to cost for my client who has a long-term ongoing illness. And I think to myself, why did you not think of this before? Because ultimately, it's not your lawyer's job to know your daily needs. That's your job. It's your job to do the homework to determine what it's going to cost and what you need in order to be able to live independently. So you need to think about those things and have answers to those questions. Again, like, do you even qualify for a loan to buy your spouse out of their equity in the house? Those are the types of things that you need to have answered before you go into mediation. Under the Texas Family Code, mediated settlement agreements are binding and enforceable. What that means is once you sign a mediated settlement agreement, the other party can take that mediated settlement agreement into court and say, Judge, I want you to enter a final court order based upon this mediated settlement agreement, and you can't change your mind. There's no mulligans, there's no take backsies. So before you sign a mediated settlement agreement, you need to have had complex conversations with your lawyer and potentially family members about your finances and how it's all going to work to make sure that it's something that is workable for you. Now, one issue that I've seen come up quite a lot is the qualifications of mediators. I have had consultations with multiple clients who have come into my office with a signed mediated settlement agreement that is awful. That is not favorable to them, and that's not just not favorable to them, it's really harmful to them in their relationship with their children. It's a really unfair financial division. It didn't take into account numerous factors that a court would likely consider if you had gone to trial. But they went to mediation without a lawyer, and they signed it. It doesn't matter. The mediated settlement agreement is still binding and enforceable. And there are people that are operating in our community as certified mediators who are not attorneys, who other than their personal experience have no experience with family law and don't understand what a judge would be reasonably likely to order. But they market themselves as mediators because I think at some point people think it's somehow less scary to go to mediation with somebody that's not an attorney and doesn't have experience in family law other than wanting to be helpful. Please be very wary of that. When mediation really works, when it works like it's supposed to, what the parties are doing is they are having frank discussions with their lawyers of, well, what am I reasonably likely to get in court versus what is it that we're going to be able to agree to? And if your partner, the person that you're breaking up with, wants something that a court would never, ever order, oftentimes it's a bad idea to agree to it unless, one, it's what you want to, or also, and two, whether it's something that you can live with in exchange for something you really want that a judge would not be reasonably likely to order. So you have to be sure that when you're engaging in a mediated settlement agreement, you're not selling yourself and your case short. Because you may have fantastic facts that if you went to court would get you a much better outcome than what the other side is willing to agree to. And sometimes that is actually what is best for families. So you need to talk to your lawyer about that and talk about the limits of what it is that you're willing to agree to, and do a real cost benefits analysis of going to trial versus agreeing to something that you really don't want just for the sake of agreement. Because not every case should be resolved in mediation. In the context of negotiating, I always talk about a $20,000 G-Wagon. And I think it's because I've always really wanted a G-Wagon. You know, the big boxy Mercedes that are really ugly. I don't know why I want one. It is what it is. All right. So I always talk about the $20,000 G-Wagon. And I want you to think of it this way. If you were to walk into a Mercedes dealership with $20,000 in cash and say, "Excuse me, sir, I want to buy that brand new $400,000 G-Wagon over there." That's right, they cost $400,000. Maybe that's why I want one, but that's another video altogether. Anyway, if you were to walk into that Mercedes dealership and say, "I want to buy that $400,000 G-Wagon for $20,000, and here's the cash right here, sell it to me," two things are going to happen. One, no salesperson is going to want to talk to you again because they don't think that you're a serious buyer. And two, you're definitely not walking out of there with that G-Wagon for $20,000. So in mediation, it's important that you are negotiating from a place of good faith and making offers and counteroffers that are reasonable. Because if you go in and everything that you ask for is shooting for the moon when you're not even in a rocket ship, you're probably not going to come to some sort of agreement. So you have to have reasonable expectations about what compromises you might make based upon the evidence and the facts of your case. Mediation can be a way to save money. It can be a way for you to learn more about what the other side will try to prove in court if you wind up in a temporary orders hearing or in final trial. It can be a way for you and your co-parent to come to decisions about what is in the best interest of your children that may not be perfect, but that you can both live with. And studies show that when people agree on the outcome of their divorce, they are much more likely to report a positive experience moving forward in co-parenting than if they go to trial and get told how the cow ate the cabbage. Okay? So for a lot of reasons, mediation is a positive thing, and it's something that you should be ready to do and that you should look forward to and that you should be hopeful about. But it can be a very difficult process emotionally. It can be very stressful, and so you need to be prepared. If your lawyer hasn't called you and said, "We want to schedule an appointment for mediation prep," give them a call and ask, "Hey, can we sit down and meet before we go to mediation? I just want to talk about our expectations, the mediator, what I can expect, and where we go from there." And that will also give you a better sense of what to expect. And, you know, as in most areas of our lives, knowledge is power. And you can request that knowledge for yourself. So don't be afraid to do that. Mediation is required in most counties in the state of Texas prior to final trial as a requirement of the court. So you also need to expect for it to happen, and don't try to buck it. It's probably going to happen. And if you think it's just a waste of time and money, we're never going to settle, some of the craziest cases I have ever had actually settled in mediation. So when you walk into that mediation room, have hope, have a clear head, have a nimble mind that's ready to pivot, and also have an open mind and reasonable expectations, and you just might come to an agreement. Normally, I end my videos by saying good luck in court. On this one, I'm going to say good luck in mediation. Hopefully you come to a fair settlement.